So how much can I get for a trade? Well, I don't think bananas are worth what you think they're worth. If shopping for a new car drives you bananas, head to Community Auto Group in Mason City. We have the best selection of new and pre-owned vehicles. And you know, with Community, you're getting a straightforward deal from a straightforward dealer. I'd like to buy this car. No? Seriously? Next time I'll skip the monkey business and go to Community Auto Group.
Environmental health, presentation of proposed dangerous dog ordinance. Brian.
All righty. Well, good morning. I'm Brian Hanna. I'm with the Environmental Health Service Section for the Health Department, and want to take the opportunity to, kind of keeping with how we've done things in the past with ordinance adoptions, is present this to the supervisors kind of as an introduction and allow for certain questions, and then I guess ask for your formal date setting for public comment and public hearing. The health department and health departments from across the state do have some ability to address dogs and other animals through the Chapter 351 of the Code of Iowa. And that code does allow the Board of Health and local law enforcement to do quite a bit. They define dogs as property. They do give stipulations in that law to kill an untagged dog. It also allows for addressing of rabies vaccinations, which is really the predominant reason I think why Board of Health are involved. If dogs are biting or have bit or have not had rabies vaccinations, or if there is an epidemic of rabies that's becoming rampant, it provides for some very specific legislation for us to deal with those situations. It also deals with dogs running at large. Local law enforcement, local boards of health can deal with those dogs that may be running at large, that may be tagged or not tagged, and then it allows us to impound those dogs and deal with them appropriately. 351 also specifies what duties a dog owner has, in the sense that making sure that the dog must have rabies vaccinations, must be tagged. It also stipulates that local boards of health and law enforcement will be notified in the case that a bite has occurred. It also allows for confinement if a dog has bitten, generally in rabies cases or in bite cases where a dog doesn't have current rabies shots. That dog needs to be quarantined for a period of 10 days. That quarantine period allows for observation to determine if that dog is showing any kinds of sign of rabies. So we can do that. We can do that how we want. Generally, that works out so that the homeowner confines that animal on their own property. We don't have to take that animal off property, as long as the homeowner is going to follow what we stipulate. If they're not, or if we don't feel like they're going to follow what we stipulate for confinement, then we can remove that animal and have it placed in a location where we can observe that animal. In the case that an owner does not pick up an animal at the end of a quarantine period, it does give local boards of health some authority to be able to deal with that animal, either through euthanasia or some other means. There are some exemptions that are included in those rules. Generally, if a dog is bitten and there's some law enforcement generally included in that. There are research institutions or like facilities shall be exempt from provision. So this gives us a lot of authority, but what it does not give us the authority to do is deal with dogs that may potentially bite and behave in a very aggressive manner, or dogs that have bitten. So what you have before you, and it's a draft, the Board of Health adopted this last week, 2 weeks ago, last Friday, and they have adopted, and then it comes before you, of course, for approval and implementation. This ordinance gives us quite a bit more ability to deal with those dogs that, number one, are potentially dangerous dogs, or are considered dangerous dogs. In other words, they have bitten. I can certainly walk through the ordinance, the proposed draft with you if you would like, and read through it for purposes of just touching on this. Dangerous dog basically means a dog that has engaged in or has been trained to engage in exhibition of fighting, attacked a person or domestic animal without justification causing serious bodily injury, behaved on 2 or more occasions in a manner that a responsible person would believe posed an unjustified threat of serious injury or death to a person, was declared to be dangerous dog by an animal control authority, court of another jurisdiction, or a governing body of another jurisdiction. So that has happened before, where a dog from another jurisdiction, i.e. another county, has been removed from, say, municipality and brought into our county. So we have then generally addressed those situations with a simple letter. So that defines specifically a dangerous dog. It defines who an owner is, which is pretty straightforward. Provocation defines what that is, and then potentially dangerous dog. This ordinance revolves around 2 very specific definitions, and the first is a dangerous dog which has basically bitten, or a potentially dangerous dog. Potentially dangerous dog is a little bit more in-depth. It's a dog that may reasonably be assumed to pose a threat to public safety, as demonstrated by many of the following behaviors: causing any injury to a person or domestic animal on private or public property that is less severe than a serious injury, without provocation chases or approaches a person, a domestic animal, or a wheeled conveyance, so i.e. a bicycle, on sidewalks or any public or private property in any apparent attitude of attack, or has a known propensity, tendency, or disposition to attack unprovoked. Acts in a highly aggressive manner within a fenced yard enclosure and appears to be to a reasonable person to be able to jump over or escape. So it talks about restraint is specifically defined here within the real property limits of the owner, and secured, confined thereupon in a physical fence, kennel, or confined indoors. I can get into as much detail as you would prefer. Serious bodily injury means laceration to an avulsion of the face of a human being, laceration to an avulsion of another area of a person's body requiring sutures, broken or dislocated bones, permanent nerve damage, partial or total loss for use of part of a body part for a significant period of time, or disability 50% or more for a significant amount of time. And then it defines trespass. It then gets into owner responsibility, which is really what this boils down to, is dog owners taking responsibility for their dogs. And again, I can read through each one of these if you would like. Every dog found to be potentially dangerous or dangerous shall be kept under restraint at all times. No dog shall trespass. Every dog within Saragota County shall be identified at all times, which is also according to 351. Talks about costs that will be borne by the dog owner. If at any time a dog is quarantined, impounded, and in the process of appeal, all costs shall be responsibility of the dog owner. So then it gets into determination of a potentially dangerous dog. It talks about what we're going to be looking for in these cases. What this also really does is provide for the dog owner some rights. There is a due process to Iowa law, and so the Board of Health was very clear in stating that is very important, that we really recognize that. So due process for a dog owner, if a dog should be addressed through this ordinance, is they're handled directly through the administrative authority, which is the Department of Public Health. If the decision's made by the Department of Public Health, they can be appealed and taken to the Board of Health, where they can make their case. And then ultimately, if they so choose, they can take that on to the courts. So if a dog is found to be a potentially dangerous dog, there's a series of different actions that we may take, and I stress may. We use that term in the ordinance. The owner of a dog shall be liable for the cost of impounding and keeping the dog for each of the requirements listed above, which are basically quarantining the dog for a period of 10 days, impound and quarantine of a dog. Anytime we have to take the dog away or impound it away from their property, then the owner is going to be responsible for those costs. Then we may require a series of different stipulations for a dog that has been found to be potentially dangerous. Of course, proof of current vaccinations, which is in line with Chapter 351 of the Code of Iowa. An identification microchip installed in the dog. The dog, while on the owner's property, shall at all times be kept indoors or in a securely fenced yard or enclosed from which the dog cannot escape. We can or may require that if a dog leaves a premise that it be muzzled. Again, these are may. These are things that we'll have to deal with on an individual case-by-case basis. We stipulated in here that we may require an obedience course be taken at the owner's expense. Again, I'm kind of summarizing here, and I can hit on these more if you would like.
Well, may I, Brian?
Yes.
I sit on the Board of Health, and that meeting 2 weeks ago, as much as in depth the audience here thinks that we're getting into, which we are, who you really dug into it then. And there's other municipalities in the state of Iowa, and of course we have the 351 state, and of course we use that as a template to go on. But there was a lot of questions asked, and we have a very good board, and we had a newer member of the board, and they were really curious on the step one. Okay, you sit on the Board of Health, and in a year's time, 12 meetings to start a new ordinance, if you will. That's a big deal, and so we're not taking this lightly. I mean, it's and the new member I know got really thrown in the fire at first, but it's a very good question. But yeah, go ahead. I'm just saying that for the benefit of everyone here.
And it's a good point. We did have a lot of dialogue, and you know, this is an ordinance I'm pretty proud of. I spent personally a lot of time researching, you know, case law. I researched other examples of ordinances. I have multiple copies that I use to help draft this. Randy Nielsen, who represents the Board of Health as far as legal advice, reviewed this and also provided in-depth comment for us to address and include. So, again, I don't want to keep diving into all the minor details on this, but we do go in and define exactly what a dangerous dog is, which is pretty important because, honestly, if a dog bites once, we basically put them on notice using this ordinance. If a dog bites again, and this is what it really boils down to, you know, dogs sometimes bite and sometimes they're provoked or unprovoked, but it gives us some latitude. If a dog bites a second time, we as a Department of Public Health feel pretty strongly that we need to be able to address a dog that has done that once and may do it again. And so that's what this does. There are some exceptions to this dangerous dog ordinance. You know, if the dog was used by law enforcement or military, obviously that's an exemption if it's acting in its official capacity. The threat or injury or damage was sustained by a person who was committing a crime at the time, willful trespass or toward upon premises lawfully occupied by the owner of the dog. So obviously somebody's trespassing and the dog bites. It's not the dog's fault, it's protecting its ground. The dog was responding to pain or injury, protecting itself or offspring. So if you try to approach a dog after it's been hit by a car or something along that line, and the dog bites, obviously then that it wouldn't apply. So then it gets into hearings. It provides for, again, the dog owner to have a period of 10 days, which they can appeal to the Board of Health. It talks about some standard issue penalties, which can be applied generally through the courts. And then applicability is basically within Saragordo County and the municipalities within its borders, unless the municipality has a current dangerous dog ordinance in effect. Okay, we had a lot of conversation about that. If Mason City, Clear Lake have their own dog ordinances, dangerous dog ordinances in place, then ours will not come in and supersede that. Okay.
They do have one in place, don't they?
Yes, they do. Yeah. So, you know, I have a lot of statistics here about dog bites that occur not only in Iowa but across the country. There's several cases that have happened in Iowa, and I don't want to get into a lot of the details, but you know, in 2011, a child was maimed and killed in Hopkinton, Iowa. Recently in the news, there was a case where a woman had her nose bit off by a dog, and the dog latched on and had to be, the article was the husband had to bite the dog back to get it to let go. You know, there's some cases where we need to be able to be aggressive and so I don't know if you have any questions, if there's any comments that I can try to hit on, or Ron or Karen, if I missed anything, they're here too. They've provided a lot of support to help make this what it is right now.
When you drafted this, is there a specific template that you drafted it off of? Obviously, there might be a master at some time.
So what we did was we received an example ordinance from the state of Iowa. Dr. Ann Garvey, who's the state veterinarian, works for the Iowa Department of Public Health, provided us with an example. And again, then I researched quite a few different ordinances to use when we put this all together. Several of them that I used. Actually, I found a dog bite law attorney who had a model ordinance that was online that proved really, really useful. So he litigates and goes in and he's provided an example dog ordinance. So that was useful. The city or county of Dubuque was used. Council Bluffs was looked at. Again, here's Clear Lakes, which I found some nice language in there as well. And then again, the model dangerous dog ordinance came straight from the state of Iowa. So there was a lot of time put into this. And so yeah, it wasn't that we just made this up on our own. This is really just an enhancement to the Chapter 351 of the Code of Iowa. The other thing I just want to stress also, the question has come up, and I've received questions from members of the media as well. This is not breed specific. We're not getting into that. We're also not getting into nuisances. We don't want to be out tracking down people whether or not they're picking up, dogs and, using the restroom in somebody else's yard. Okay, that's not what we're getting into. We're trying to deal with vicious animals, vicious dogs that may impact, threaten, or hurt a human being. And having the ability to address those on a case-by-case basis if needed.
Questions for Brian, gentlemen?
Well, I do think it looks like you did a nice job on the draft. And I can't see why we can't at least schedule a public hearing and stuff for it.
Okay.
Do you have a date in mind?
Michelle and I talked, it sounds like July 9th we can start with and see what kind of comments we receive.
Okay. July 9th
At 9:45.
Okay.
We have a motion to that effect.
So moved.
Okay, and I'll second it.
Okay, motion made and seconded to set July 9th, 2013 at 9:45 is the time for the public hearing on the proposed dangerous dog ordinance. All in favor?
Aye.
Aye.